This is Angela, and you're listening to the Study for the Bar in Your Car podcast, the podcast where we use AI to study for the bar exam, and the podcast where you can turn drive time into study time. Anyhow, I'm your host, Angela. I am here with my two AI co-hosts, Claude and Maud. So here's how it works. I have taken really copious notes over the years studying for the bar exam, and I have put all my notes into AI, and the AI creates a podcast. So basically, you're listening to a podcast within a podcast. So you'll hear Claude and Maud going over all of my notes. So we have done it. We have made it to the end of contract law. Yay. So contract law is, I wouldn't say it's one of my favorites, but I don't hate it like I used to. And I feel like with contract law, it really took me a long time to grasp these concepts. And I would say that's one of the advantages of being a JD over an LLM student. So as you may know, I am a dual American British citizen. I got my first law degree overseas in the UK, and I got my second law degree, an LLM, from George Mason University. And I actually did a second LLM on top of that. So when you're an LLM student, the courses that you take probably don't go into as much depth as the courses that JDs take. It really depends on your school and the courses that you take. But I think what you find generally that JDs do better on the bar exam than LLMs. And I think the statistic is like only 43% of LLMs pass the bar exam on their first time. And I certainly didn't pass it on my first time. So I really hope that you've enjoyed this series so far. I'm still experimenting with the format, whether to go it alone or to have a co-host or to have, even more AI co-hosts than Claude and Maud. And I'm just still figuring things out. And that's another reminder. I'm a student just like you, so I'm not some big expert on this. I just am someone who takes really good notes, and I know a little bit about AI, and I've been able to put my notes into AI and create these podcasts. So if you have any questions about this podcast, or if you're an attorney, or if you know an attorney and you have too much work on your hands and you need a little bit of help, hire me. I am a law clerk. I'm a freelance remote law clerk, and I help attorneys across the United States. I do motions, writs, appeals, etc. So you can email me for legal stuff at hello@legalwriterandlawclerk.com. Regarding the podcast, you can email me at podcast@studyforthebarinyourcar.com. So we are bringing it home with contract law. Yay. We will next go on to evidence. And for evidence, I'm going to take a little bit of a break. So as I mentioned, I am playing around with these formats here. And you've heard me talk on these podcasts. I don't know if some of you find me annoying or if you find the other voices annoying. But for evidence, I'm just going to let Claude and Maud host the whole thing. And then I'll come back with the next topic after that, and you'll hear me top and tail the podcast episodes. Anyhow, without further ado, take it away, Claude and Maud.
Welcome back to the Deep Dive, presented as the Study for the Bar in Your Car podcast. We've really been through it with contracts law, haven't we?
Yeah.
Looking at all those promises and agreements.
We certainly have. And today's a wrap-up.
That's right. We are bringing it all home.
Mm-hmm.
This is our final, really comprehensive look at contracts.
It's a big one. This deep dive finishes our journey through contracts. It's just such a fundamental area, isn't it? Covers, the bedrock of so many legal relationships.
Absolutely. And, we really couldn't have done any of this without Angela. She's a fellow law student, and her archive of law school notes has just been phenomenal. It's been the roadmap for this whole contract series.
Invaluable, really. Her outlines give you that structure you need, especially for bar prep. So today's mission is basically to revisit those core principles, pull everything together we've covered, using her notes as our guide.
From how contracts start to, what happens when they break down and who else might get pulled in.
Exactly. We're going to cover formation, defenses, performance, remedies, the whole lot.
Okay, so as we dive in, just a reminder, we'll be referring to the material as Angela's notes or her outlines, or sometimes her law school notes. It's all drawing from that great resource she compiled.
Right. So let's jump back to square one, the absolute first question you always have to ask in a contracts problem.
The million-dollar question. Do we even have a contract? Angela's notes lay out that really useful three-step analysis. 1, is there a contract? 2, was it performed or breached? 3, what are the remedies?
Precisely. And we'll hit all 3, but nailing down step 1 formation, actually having an enforceable contract, that's where it all starts.
Okay, formation. So that kicks off with mutual assent, the whole meeting of the minds idea. But her notes make a big point that it's not really about what people are thinking inside their heads, is it?
No, not subjectively. That's the key takeaway here. Mutual assent is judged objectively. What would a reasonable person looking at everything, the words, the actions, what would they think was agreed? Her notes point to the restatement sections 18, 22, 24 on this. It's fundamental.
Okay, objective standard. And mutual assent breaks down into offer and acceptance.
Exactly. So let's tackle offer first. What makes something a real valid offer, according to her outlines?
Right. Not just, casual talk.
Right. A valid offer is, it's a manifestation of willingness to enter into a bargain. It has to be communicated so the other person reasonably understands that just by saying yes. They seal the deal. It shows like a present intent to be bound on specific terms. Restatement sections 18 and 24 again.
So it's got to be more than just, hey, I might sell my car, or testing the waters.
Much more, yeah. Her notes draw a clear line between offers and just, preliminary negotiations or invitations to make an offer. Things like, I'd consider selling for, or I quote you this price. Usually, those are just opening moves, not a commitment to be bound right then and there.
Okay, so what are the must-haves for a statement to actually be a valid offer?
Well, it needs to be reasonably certain in its terms, and it has to be communicated to the person who can accept it, the offeree.
Reasonably certain. What does that usually mean?
Typically means you can identify the parties, the subject matter is clear, and there's a price, or at least a way to figure out the price. Restatement section 33 covers that certainty aspect.
And how do courts figure out if someone really intended to make a binding offer? What factors do they look at?
Angela's notes lists a few key things. The actual language used was a definite, I offer, or more wishy-washy. The surrounding circumstances are important too, any prior dealings between the parties. And how was it communicated? Like an ad in the paper is usually just an invitation for you to make an offer, not an offer itself.
Unless it's a reward, right? Like Lost Dog, $100 reward.
Exactly. Reward offers are often specific enough to be offers inviting performance.
And there's a special rule under the UCC for the quantity term in sales of goods contracts.
Yes, good point. Under UCC Article 2, for goods, the quantity term is generally pretty essential for certainty. UCC 2201, the Statute of Frauds section, kind of highlights this, but it applies to offer certainty too.
But what about those requirements contracts or output contracts? They don't have a fixed number.
Right, and her notes explain those are okay. Requirements contracts, I'll buy all the widgets I need from you, and output contracts, I'll sell you all the widgets I produce, are valid because the quantity, while not a specific number, can be figured out objectively based on the buyer's actual good faith needs or the seller's actual good faith output. UCC 2306-1 covers this. They're not illusory.
Okay. What if some terms are just left out? Does that kill the deal automatically?
Not necessarily, and this is important from her notes. If the parties clearly intended to make a contract and there's a reasonable way for a court to figure out a remedy, missing terms don't automatically prevent formation. Courts, especially under the UCC, can supply gap fillers for things like a reasonable price or time for delivery if the contract is silent. Think UCC 2204-2305.
But there's a limit, right?
Oh, definitely. Her notes caution that the more terms you leave open, the less likely it looks like you actually intended to be bound in the first place. It's a sliding scale.
Okay, makes sense. So we have a valid offer on the table. How does the other side accept it?
Acceptance is basically the offeree saying yes to the offer's terms. It can be done by making a promise back that creates a bilateral contract. Or it can be done by performing an action that makes a unilateral contract.
Bilateral is the classic, I promise to sell, you promise to buy.
Exactly. The standard promise for a promise deal. Her notes use the Blackacre example. Sydney promises to sell for $6K. Bertram promises to buy for $6K. Boom. Bilateral contract formed right then.
And unilateral is where the offer asks for an action, not a promise back.
Right. The offeror wants performance. The contract isn't formed until the act is completed. The example in her notes is Susan offering Charles $5 if he delivers a textbook. Charles doesn't promise anything. The contract forms only if he actually makes the delivery.
Her notes had some interesting points about unilateral acceptance. Like, you have to know about the offer.
Crucial point. You can't accidentally accept a unilateral offer. You have to know the offer exists when you perform the act. The waiter example is good. He catches a thief, but he hadn't seen the reward poster yet. No contract, no reward, because he didn't perform in response to the offer.
And starting the performance can sometimes make the offer impossible to revoke.
Yes, that's a key protection for the offeree under Restatement Section 45. Once the offeree starts the requested performance, the offeror generally loses the power to just yank the offer back. They have to give the offeree a reasonable time to finish. The example is Matt offering Lisa $1,000 to paint his house. Once Lisa starts painting, Matt can't just say, never mind. If he stops her, he's the one in breach.
What about just getting ready to perform? Like Lisa just buys the paint? Is that starting?
Usually no, according to her notes. Mere preparations aren't typically considered starting performance for that rule, but substantial preparations might trigger protection under promissory estoppel if the offeror could foresee the reliance and it would be unjust not to enforce the promise. That's more like Restatement Sections 87 or 90 territory.
Okay. Can starting performance ever count as acceptance for a bilateral contract offer?
Yes, it can. If the offer invites acceptance by either promise or performance, then starting the performance can operate as acceptance. But there's a catch her notes mention from Restatement 54 and UCC 2206. If the offer wouldn't normally know performance has started, the offer usually needs to give notice within a reasonable time. If they don't, the offer might just lapse.
Like the chip maker starting production. They need to tell the electronics company.
Exactly. Otherwise, the electronics company might think no one accepted and go elsewhere.
Got it. So offers don't last forever. How do they end before someone accepts?
Several ways. The offeree can reject it flat out, or they can make a counteroffer. The offer can lapse after a set time, or a reasonable time if none is stated. The offerer can revoke it before acceptance, or, sadly, if either party dies or becomes legally incapacitated.
A counteroffer kills the original offer, right? It's not just tweaking it.
Right. That's a critical point from her notes in Restatement Section 39. A counteroffer proposes different terms on the same subject. It acts as a rejection of the first offer and, at the same time, becomes a new offer from the original offeree back to the original offerer.
And the UCC has its own famous, or maybe infamous, rule for acceptances with different terms. Section 2207.
Yes, the battle of the forms. Her notes tackle this. Section 2207 deals with situations common in business, where an acceptance document includes terms that are additional to or different from the offer.
How does it work if one party isn't a merchant?
In that case, the additional or different terms are just treated as proposals to modify the contract. They don't automatically become part of the deal unless the original offeror specifically agrees to them.
So, no sneaking terms in against a consumer, for example.
Generally, no. It's different if both parties are merchants. Then additional terms can become part of the contract automatically unless the offer limited acceptance to its own terms, or the new terms materially alter the deal, or the offer objects within a reasonable time. It's more complex between merchants.
What about accepting an order by just shipping the goods?
Under UCC 2206, shipping goods is usually acceptance. But here's the twist her notes highlight. If a seller ships non-conforming goods, that shipment is typically both an acceptance and a breach of the contract.
Ouch. Any way around that?
Yes, the seller can ship the non-conforming goods as an accommodation. If they notify the buyer promptly that the shipment is just an accommodation, basically, we don't have what you ordered, but here's something else, take it or leave it, then it's not an acceptance, it's treated as a counteroffer.
Like the widget example, sending black instead of blue.
Exactly. Ship black widgets without saying anything. Acceptance and breach. Ship black widgets saying, shipping these as an accommodation. Counteroffer. The buyer can then accept the black ones or reject them.
Okay, that really covers offer and acceptance, mutual assent. What's the next piece we need for a traditional contract?
Consideration. That's the bargain for exchange.
Bargain for exchange, meaning both sides have to get something or give something up?
Pretty much. There has to be a legal detriment incurred or a legal benefit received by each party, and it has to be bargained for, meaning the promise induces the detriment and the detriment induces the promise. It's the price paid for the promise.
Does the value have to be equal? Does it have to be a fair trade?
Nope, and this is key. Her notes, citing the peppercorn rule and Restatement 79, make it clear. Courts generally do not care about the adequacy of consideration. As long as something of legal value is exchanged, even if it seems tiny or unfair later, consideration is usually satisfied. Gross inadequacy might signal a defense like fraud or duress, but it's not lack of consideration itself.
It's like the topaz example in her notes. Selling a stone without knowing its true value.
Exactly. They bargained for the exchange, assuming the risk about the stone's value. Even if one side got a much better deal, there was still consideration.
What if a promise isn't really a promise? Like it's totally optional, an illusory promise.
That's a way a contract can fail for lack of consideration. Her notes warn about this. If one party's promise leaves performance entirely up to their own discretion, like, I'll buy if I feel like it, then it's illusory. They haven't actually committed to anything, so there's no consideration to make the other party's promise binding.
The chef example. I'll buy as much ice cream as I want.
Perfect example. The chef isn't bound to buy any ice cream, so the dairy's promise to sell isn't supported by consideration.
And the pre-existing legal duty rule. That affects modifications, right? Under common law.
Yes, classic common law rule. Her notes explain that doing something you're already legally obligated to do under an existing contract generally doesn't count as new consideration for a promise to modify that contract.
Like the pool company offering free patio paving because they were late on the pool.
Right. They were already obligated to finish the pool. The homeowner wasn't giving anything new in exchange for the patio promise, so under common law, that modification promise wasn't binding due to the pre-existing duty rule.
But the UCC is different for modifications.
Big difference, yes. UCC 2209 says modifications to contracts for the sale of goods need no new consideration to be binding. The only requirement is that the modification is made in good faith. Huge departure from common law.
Okay, so offer, acceptance, consideration for standard contracts. But Angela's notes also talk about times when promises are enforced without that traditional bargain for exchange.
Right. These are crucial fallback theories based on fairness and preventing injustice.
Like promissory estoppel, reliance.
Exactly. Promissory estoppel can make a promise enforceable even without consideration if certain elements are met. Her notes, citing Restatement 87.2 and 91, lay them out. 1. A promise that the promisor should reasonably expect to induce action or forbearance. 2. The promise does induce that action or forbearance. 3. The promisee relies to their detriment, changing their position. 4. Injustice can only be avoided by enforcing the promise.
The grandmother promising tuition example fits here.
Perfectly. Grandma's promise might lack consideration, but the grandson reasonably relied on it by enrolling and buying books. That detrimental reliance makes her promise enforceable, at least to the extent needed to prevent injustice, maybe covering the cost of those books and tuition paid.
And the other one is restitution, or quasi-contract.
This is totally different. It's not about enforcing a promise at all. It's an obligation the court imposes to prevent unjust enrichment. If Party A confers a benefit on Party B, B knows about it, and it would be unfair for B to keep it without paying, the court might make B pay the reasonable value of the benefit.
Like the roofer accidentally fixing the wrong neighbor's roof in her notes.
Yes. The neighbor got a new roof, a benefit. Even with no contract, the neighbor might have to pay something in restitution if they knowingly accepted the benefit when they could have stopped it, or if it would just be unjust for them to keep it for free.
Her notes also mention the material benefit rule.
Right, that's related. Restatement Section 86. It can sometimes make a later promise to pay for a past benefit enforceable if the promise is needed to prevent injustice. Like, if someone saves your life and later you promise to pay them $10,000, that promise might be enforced under this rule, even though the saving happened before the promise.
Okay. And just circling back to modifications quickly, the key difference is common law needs new consideration. UCC just needs good faith for goods.
That's the core takeaway from her notes on modification. Keep that distinction straight.
All right, so we know how contracts are formed, even sometimes without consideration. Now, what about things that can stop a seemingly valid contract from being enforced? Defenses.
Exactly. Even if you have offer, acceptance, and consideration, a defense might make the contract unenforceable. And her notes distinguish between void and voidable contracts.
Void means it's the total nullity, right? Like illegal from the start.
Right. Unenforceable by anyone. Voidable means one party, usually the injured or protected one, has the option to either enforce the contract or get out of it. Think contracts with minors or ones based on fraud.
Let's run through some major defenses. Incapacity.
Incapacity means a party lacked the legal ability to contract. Her notes cover two main groups: minors, or infants as the law calls them, and those with mental incapacities.
Minors can get out of contracts.
Generally, yes. Contracts entered into by a minor are voidable at the minor's option. They can disaffirm the contract any time while they're still a minor and for a reasonable time after reaching the age of majority.
But they can also choose to stick with it after turning 18.
Yes, that's called ratification. They can ratify expressly, okay, I agree to be bound now, or by conduct, like continuing to perform or accept benefits under the contract after reaching majority. The example in her notes of the teenager continuing to mow the lawn after 18 shows ratification by conduct.
Are there exceptions? Can minors always disaffirm?
Not for necessaries. Her notes explain minors can't avoid contracts for essential things like food, clothing, shelter, medical care, but they're usually only liable for the reasonable value of the necessaries received, often under a quasi-contract theory, not necessarily the full contract price.
And mental incapacity. Similar idea.
Pretty similar. If someone lacks the mental capacity to understand the nature and consequences of the transaction when they enter the contract, it's voidable by them or their guardian. They can ratify during a lucid interval or after regaining capacity. And like minors, they're typically liable in quasi-contract for necessaries.
What about defenses based on unfair pressure, duress, or undue influence?
Duress makes a contract voidable if assent was induced by an improper threat that left the party with no reasonable alternative.
What kind of threat is improper?
Could be a threat of physical harm, obviously, but her notes mention it can also be threats to property or even wrongful economic threats, like threatening to breach another contract in bad faith to extract a modification. The key is both an improper threat and the lack of any reasonable alternative for the victim.
The example about Barry in foreclosure, his duress defense might fail if he had other options, like finding a job.
Exactly. It highlights that no reasonable alternative element. If there were other ways out, even if unpleasant, a duress defense might not succeed.
What if the threat comes from a third party, not the other contracting party?
Her notes say duress by a non-party can still make the contract voidable. But if the other party to the contract acted in good faith, didn't know about the duress, and gave value or relied, the contract might still be enforceable against the victim by that innocent party.
Okay, how about mistakes? When do they let someone out of a deal?
We're usually talking about mutual mistake here. Her notes explain this happens when both parties are mistaken about a basic assumption of fact that existed when the contract was made, and the mistake has a material effect on the agreed exchange.
But not if someone took the risk of being wrong.
Crucial exception. If the party trying to avoid the contract assumes the risk of the mistake, the defense won't work.
Like the Topaz example again. They didn't know the value for sure, so they assumed the risk.
Exactly. The mistake about value was mutual and material, but because they contracted despite that uncertainty, they were held to have assumed the risk. No avoidance based on mistake there.
All right, let's talk about lies and hiding things. Fraud, misrepresentation, non-disclosure.
This representation makes a contract voidable if a party's assent was induced by an untrue assertion of fact from the other side. That assertion has to be either fraudulent, made knowingly or recklessly false, or material, likely to induce a reasonable person to agree, and the reliance on it must have been justified.
So a false statement of fact, not just an opinion.
Generally, yes. Her notes clarify that puffing or opinions, this car is great, usually aren't actionable misrepresentations, but a false statement about, say, past profits of a franchise, like in the donut example from her notes. That's a factual assertion that could support a claim if it was fraudulent or material and relied upon.
What about not saying something? Just keeping quiet.
That's non-disclosure. Usually there's no duty to disclose facts to the other party, but her notes point out exceptions. Concealment, actively hiding a fact, is treated like a misrepresentation, and non-disclosure can be actionable if there's a duty to speak, like to correct a previous statement that's now known to be false, or if there's a relationship of trust. Restatement sections 159, 161, 164 cover this.
Illegality seems pretty clear-cut. If the contract is for something illegal, it's no good.
Pretty much. Her notes state illegality makes a contract void. If the subject matter, consideration, or performance is illegal, or if the formation itself violates the law, courts generally won't enforce it for anyone.
Unconscionability is maybe a bit fuzzier. When something shocks the conscience.
It is a bit more flexible. Unconscionability allows a court to refuse to enforce a contract or a term if it's found to be outrageously unfair at the time it was made. Her notes explain courts usually look for two things: procedural unconscionability, unfairness in the bargaining process, like unequal power, hidden terms, no chance to negotiate, and substantive unconscionability. The terms themselves are overly harsh or one-sided.
Like the employer arbitration clause example, one-sided and non-negotiable.
Exactly. That example shows how a combination of procedural issues, standard form, take it or leave it, and substantive issues, only the employee had to arbitrate, could lead a court to find the clause unconscionable and unenforceable.
And contracts can also be void if they violate public policy.
Yes, even if not strictly illegal. If enforcing a contract would violate some strong, established public policy, courts might refuse to do so. Her notes mention the example of how courts interpret permanent employment contracts. Usually they're still terminable at will unless the termination violates a clear public policy.
Okay, the big one. The Statute of Frauds. Certain contracts need a signed writing.
Yep, the SOF. It's a defense saying, even if we had a deal, it's unenforceable because it wasn't in the required written form. Her notes highlight the main types. Contracts involving interests in land, but usually not short-term leases or easements, and contracts that cannot possibly be performed within 1 year of being made.
That 1-year rule. What's the key thing to remember?
The possibility of performance within a year, her notes really stress this. If there's any way, no matter how unlikely, the contract could be fully performed within 1 year from formation, it's outside the SOS and doesn't need a writing.
Right, the 6-year insurance contract example. The house could burn down in month 1.
Exactly. Since full performance, paying the insurance, is possible within a year, that oral contract falls outside the 1-year rule, even though the stated term is longer.
And the UCC has its own SOF for goods over a certain amount.
Right. UCC 2201. Contracts for the sale of goods for $500 or more need a writing signed by the party being sued. And her notes add a crucial point. The contract is only enforceable up to the quantity of goods stated in the writing.
The gear example. Oral deal for $3,000. Writing says $2,000. Only $2,000 are enforceable.
Precisely. The writing caps the enforceable quantity under the UCC SOF.
What if you modify a contract? Does the modification need to be in writing?
Depends. Her notes say if the modification brings the contract as modified within the Statute of Frauds, then the modification itself generally needs to be in writing. The security system example shows this. Oral contract for $400 outside SOF. Modified to $700. Now it's over $500, so the modification needs writing under UCC 2201.
Are there ways around the writing requirement, exceptions to the SOF?
Yes, several important ones. For land contracts, her notes mention part performance. Usually this requires the buyer taking possession and either paying part of the price or making valuable improvements. The farmer-rancher example, where the rancher did all three, makes the oral land deal enforceable.
Any exceptions for goods under the UCC?
Yes, specially manufactured goods. UCC 22013. If goods are custom-made for the buyer, not easily resellable, and the seller has substantially started making them or committed to getting them before repudiation, the oral contract can be enforced without a writing.
Can promissory estoppel overcome the SOF? Like if someone relied on an oral promise?
Her notes indicate that many courts will allow promissory estoppel as an exception to the SOF if enforcing the statute would result in injustice due to detrimental reliance on the oral promise, especially reliance on a promise that a writing would be executed or that the SOF wouldn't be raised.
And the signature requirement, does it have to be a full autograph?
No, her notes say it's interpreted pretty broadly. Initials, a typed name, even letterhead, or an electronic signature can work if it shows intent to authenticate the writing. The Uniform Electronic Transactions Act, UETIA, supports electronic signatures.
Okay, that covers defenses. Now, assuming we have an enforceable contract, how do we figure out what it actually means? Contract content and meaning.
Right. This involves interpretation and the Parol evidence rule.
Interpretation goes back to that objective theory, right? What a reasonable person would think.
Exactly. It's about the objective meaning of the words and conduct, not secret subjective intentions.
If the contract language is confusing or seems contradictory, is there a pecking order for figuring out the meaning?
Yes. Her notes lay out a hierarchy courts use. Express terms written in the contract itself are given the most weight. Then, the course of performance, how the parties acted under this specific contract. After that, course of dealing, how they acted in past similar contracts. And finally, usage of trade standard practices in the industry or locality.
Okay. Now, the parole evidence rule. It sounds like it blocks outside evidence.
That's the general idea. Her notes explain that if parties have a written agreement that they intend to be the final expression of their deal, called an integration, the parole evidence rule prevents parties from bringing in evidence of prior written agreements or contemporaneous oral agreements to contradict or vary the terms of that final writing.
What's the difference between a partial and a complete integration?
An integration is just the final writing. Her notes explain a partial integration is final regarding the terms it does contain, but it might not be the entire agreement. If it's partial, you can bring in extrinsic evidence of consistent additional terms as long as they don't contradict the writing and aren't terms that would naturally have been included.
Like the cleaning service example. Contract didn't mention the elevator day?
Right. If the court decides the written contract was only a partial integration, evidence of a prior oral agreement to also clean the elevator bay might be admissible because it's a consistent additional term. Same with the balloon shipping example, written form silent on method. Oral agreement for next day shipping might come in if it's just a partial integration.
And a complete integration.
That's where the parties intended the writing to be the final and exclusive statement of all terms. If it's a complete integration, the parole evidence rule is stronger. It generally bars any extrinsic evidence of prior or contemporaneous agreements that would add to or contradict the writing, even consistent additional terms.
So when can you use outside evidence, even with a written contract?
The rule has limits. Her notes list key situations. You can always use extrinsic evidence to help interpret or explain ambiguous terms in the writing, because you're clarifying, not contradicting. You can use it to show that a defense exists, like fraud, duress, mistake, or lack of consideration. And the rule doesn't apply to agreements made after the writing's subsequent modifications aren't barred by the PER.
The car wash example showed trade usage couldn't contradict an express term.
Right. If the writing clearly says no discounts, evidence of a trade custom allowing discounts would likely be barred by the PER because it directly contradicts the express term.
Beyond expressed terms in interpretation, are there terms implied into contract?
Yes. We mentioned the UCC gap fillers. If a sales contract is silent on price, delivery, etc., the UCC fills those gaps with reasonable terms unless the parties agreed otherwise, which includes course dealing performance, trade usage.
And the big one, the duty of good faith and fair dealing.
Absolutely. Her notes stress this is implied in every contract, common law, and UCC, Section 1304. Parties have to act honestly and adhere to reasonable commercial standards of fairness in performing and enforcing the contract. You can't escape it. The Y Corp Dominic Stress's example showed this an exclusive dealing contract implied a duty to use best efforts to sell the dresses based on good faith.
Okay, moving on to the action phase. Performance, breach, and discharge. What's required for performance?
At common law, the general standard is substantial performance. A party basically fulfills their obligations if they perform the essential purpose of the contract, even with minor defects.
But for goods under the UCC, it's stricter, the perfect tender rule.
Right. UCC Section 2601 generally requires the seller's delivery and the goods themselves to conform perfectly to the contract terms. Any deviation, however small, can technically be a breach, allowing the buyer to reject.
And that good faith obligation applies throughout performance, too.
Always. Her notes reiterate it. Parties must perform and enforce their contract rights in good faith. UCC 1304 is explicit on this.
Let's unpack conditions. How are they different from promises?
A condition, as her notes explain, is an event that isn't certain to happen, but it must happen, unless excused, before a party's duty to perform becomes absolute. It can trigger a duty or extinguish one. A promise is a commitment to act, breach a promise, damages, fail a condition. The duty it's linked to might be excused. Big difference.
What kinds of conditions are there?
Express conditions are stated right in the contract if, provided that, on condition that. Constructive conditions are implied by law, usually to ensure fairness or order performance, like one party needing to perform first if their performance takes time.
Express conditions can be based on someone's satisfaction.
Yes, conditions of satisfaction. Her notes explain the standard depends on the subject matter. If it's personal taste or judgment, like a portrait, tailored suit examples from her notes, it's a subjective standard. The party must be personally satisfied, but honestly and in good faith. If it's about utility or mechanical fitness, it's an objective standard. Would a reasonable person be satisfied? But even then, dissatisfaction must be in good faith. Bad faith rejection excuses the condition.
And constructive conditions often determine the order of performance.
Exactly. If performances can happen simultaneously, like payment and delivery of goods, they're usually concurrent constructive conditions. If one takes time, building the house. Completing that performance is usually a constructive condition precedent to the other party's duty, payment. The tenant needing to notify the landlord before the landlord's repair duty arises is another implied condition example from her notes.
Can conditions be excused? Meaning performance is due even if the condition didn't occur.
Yes, several ways. Prevention is one. You can't hinder the condition yourself and then rely on its failure. The buyer failing to even apply for the mortgage in her notes. They likely can't use the lack of financing, the condition, to get out of buying the house because they prevented it.
Waiver and estoppel, too.
Right. The party who benefits from a condition can waive it by words or conduct. Her note suggests continuing performance despite knowing a condition failed often acts as a waiver. Estoppel occurs if one party's conduct leads the other to detrimentally rely on the idea that the condition is excused or satisfied. These are different from modification, which needs consideration at common law.
Does an actual breach excuse the other side's duty?
A material breach by one party generally excuses the other party's duty to perform under common law. A minor breach usually just suspends the duty temporarily, giving the breaching party a chance to cure. It doesn't discharge the non-breaching party entirely. Her notes discuss factors for telling material from minor breaches.
What about anticipatory repudiation? Breaching before you're supposed to perform.
Right. This is when a party clearly and unequivocally indicates, before their performance is due, that they will not or cannot perform. If that threatened non-performance would be a material breach, the anticipatory repudiation itself is treated as an immediate breach. Her notes, citing Restatement 253 and UCC 2610, say this excuses conditions on the other party's performance and gives them options. Sue immediately, wait, or suspend their own performance.
Like the motorcycle dealer example manufacturer says they can't deliver due to a strike.
Yes, that's a clear statement of inability to perform before the due date. Same with the concrete seller demanding a higher price, saying, I won't deliver unless you pay more, is often an anticipatory repudiation.
The UCC has that special rule for when you just get nervous the other side might breach. Adequate assurances.
Yes, UCC 2609, very useful. If you have reasonable grounds for insecurity about the other party's performance, you can demand adequate assurance in writing. If they don't provide it within a reasonable time, max 30 days under UCC, you can treat that failure as an anticipatory repudiation.
What counts as reasonable grounds or adequate assurance?
Her notes say it's based on commercial standards. A rumor might not be enough, but seeing a supplier's factory burn down probably is. Adequate assurance needs to be commercially reasonable, too. A vague promise might not cut it, like the caterer example where their assurances didn't actually show they could handle the event despite a strike.
Can someone take back a repudiation?
Yes. Under UCC 2611, they can retract it unless the other party has already materially changed their position in reliance or canceled the contract or indicated they consider the repudiation final.
Okay, let's dive deeper into UCC breach. Perfect tender rule again.
Right, UCC 2601. Any nonconformity allows the buyer to reject or accept all or accept some commercial units and reject rest.
So if the goods aren't perfect, what are the buyer's options?
Her notes say they can reject, but they need to do it reasonably quickly after delivery inspection and notify the seller, UCC 2602. Importantly, rejecting conforming goods, wrongful rejection, is itself a breach by the buyer.
Does the seller get a chance to fix the problem?
Yes, the right to cure under UCC 2508. If the contract time hasn't run out, the seller can notify the buyer and make a conforming delivery within that time. Even if time has expired, the seller might get a reasonable further time to cure if they had reasonable grounds to believe the non-conforming goods would be acceptable, maybe based on past deals.
What if the buyer just keeps the non-conforming goods, accepts them?
Acceptance happens in a few ways under UCC 2606. Explicitly saying I accept, failing to reject after a reasonable chance to inspect, or doing something inconsistent with the seller's ownership. Once accepted, the buyer generally has to pay the contract price, UCC 2607. They can still sue for damages from the nonconformity if they gave notice, but they've accepted the goods.
The piano example school accepted baby grands instead of concert grands. Still had to pay.
Yes, illustrates acceptance means you owe the price for what you accepted, even if it wasn't exactly right. Damages might still be available for the difference, though.
Can acceptance ever be undone?
Yes, revocation of acceptance under UCC 2608. It's harder than rejection. The buyer can revoke if the nonconformity substantially impairs the value to them. And D, they accepted either because they reasonably assumed it would be cured and it wasn't, or R, because the defect was hard to discover, or they were assured it wasn't a problem.
Like the SUV that couldn't tow the boat. in her notes.
Perfect example. The defect substantially impaired the value for the buyer's specific purpose, which they communicated, so revocation was possible.
How about installment contracts delivered in batches?
Different rule, UCC 2612. The buyer can only reject an installment if the nonconformity substantially impairs the value of that installment and can't be cured. A minor defect in one shipment usually isn't enough to reject it, let alone cancel the whole contract. The whole contract is only breached if a nonconformity in one or more installments substantially impairs the value of the entire contract.
The burnt rolls example, rejecting one bad batch doesn't necessarily kill the whole year's contract.
Exactly. Unless that one bad batch somehow ruins the whole ongoing relationship or makes future performance unreliable, you generally can't cancel the whole deal over one subpar installment.
All right, moving to how duties end. Discharge. Best way is just doing what you promised.
Full performance by both sides. That's the ideal discharge.
But parties can also just agree to call it quits.
Yes, mutual rescission. Her notes describe this as a new agreement where both parties agree to cancel the original contract. It generally only works if both sides still have some performance remaining, executory duties.
What's accord and satisfaction? Sounds like settling a dispute.
It often involves that. An accord is the agreement to accept a different future performance to satisfy an existing duty. Satisfaction is the actual performance of that new agreement. Her notes stress the original duty is just suspended by the accord. It's only discharged when the satisfaction happens. There usually needs to be consideration for the accord, often found if the original debt was unliquidated or disputed.
Like the engineer settling a disputed $5 bill for $30K. The agreement is the accord, the payment is the satisfaction.
Precisely. And her notes mention UCC 3311 about checks marked payment in full, potentially creating an accord and satisfaction for disputed debts.
How is that different from a substituted contract?
Key difference from her notes.
Okay.
A substituted contract immediately replaces and discharges the old contract the moment the new agreement is made. An accord just suspends the old duty until the new performance satisfaction is done. If the accord isn't satisfied, the non-breaching party can usually sue on either the original contract or the accord agreement.
And novation involves a third party.
Yes. Novation is a type of substituted contract where all three parties, the original two plus a new party, agree to substitute the new party for one of the original ones, completely releasing the original party from their obligations. The Hollywood actor being replaced by the stage actor with the producer's consent. In her notes, that's a novation, discharging the first actor.
We also mentioned impossibility, impracticability, and frustration of purpose. These excuse performance too.
Yes, major excuses for non-performance leading to discharge. Her notes cover them. Impossibility is when performance becomes objectively impossible after the contract, through no fault of the party. Think destruction of unique subject matter, the specific painting burns, or death incapacity in a personal service contract.
Impracticability. Not quite impossible, just really, really hard.
Sort of. Under UCC 2615 and common law, it's when an unforeseen event makes performance extremely and unreasonably difficult or expensive. More than just a price hike, it has to be a fundamental change based on an assumption that didn't pan out, like a war cutting off the only supply source. And the party can't have assumed the risk.
And frustration of purpose. Performance is possible but pointless.
Exactly. An unforeseen event occurs that completely undermines the reason both parties entered the contract. The classic example is renting a room to watch a coronation parade that gets canceled. You can still use the room, but the whole purpose, understood by both sides, is gone. Her notes likely cover this. If the principal purpose is substantially frustrated, duties can be discharged.
So these are all ways duties can end without full performance due to outside events.
Right. They discharge the remaining duties because the fundamental basis of the contract has changed unexpectedly.
Okay, final big section. Remedies. What happens when there is a breach and duties aren't discharged?
This is about making the non-breaching party whole. The primary goal, as her notes stress, is to protect the expectation interest.
Expectation interest, putting them where they would have been if the contract was performed.
Exactly. It's about giving them the benefit of the bargain, not punishing the breacher. Punitive damages are generally not available in contract cases unless there's also an independent tort involved.
How do you calculate these expectation damages?
The basic formula her notes likely outline is loss in value, what you expected minus what you got, plus other loss, incidental and consequential damages, cost avoided, expenses saved by not having to finish performing, loss avoided, benefits gained from salvaging resources.
And you have to be able to prove damages.
Yes, with reasonable certainty. Her notes emphasize this. You can't recover for purely speculative losses, but if the fact of damage is clear, courts might be a bit more flexible on proving the exact amount, often resolving doubts against the party who breached.
Foreseeability is a big limit, right? Especially for those other losses.
Huge limit, especially for consequential damages. This is the Hadley v. Baxendale rule from her notes. Losses that result from the injured party's particular circumstances are only recoverable if the breaching party had reason to foresee them as a probable result of the breach at the time the contract was made.
Like the plumber example. Not getting paid doesn't foreseeably lead to huge medical bills.
Right. Those weren't foreseeable consequences of a simple payment breach at the time the plumbing contract was formed.
Causation and mitigation also matter.
Absolutely. The breach must actually cause the damages, and the non-breaching party has a duty to take reasonable steps to reduce their losses. Her notes stress you can't recover for damages you could have reasonably avoided. The architect finding another job mitigated her damages.
Can parties just agree on damages beforehand in the contract?
Yes, through liquidated damages clauses. But her notes explain these are only enforceable if there are a reasonable forecast of potential damages at the time of contracting, and actual damages would be difficult to calculate. If the amount is excessive and looks like a penalty designed to punish, courts won't enforce it.
What if money just isn't enough to fix the problem?
Then we look at equitable remedies. These are discretionary and only granted if legal remedies, money damages, are inadequate.
Like specific performance, forcing someone to go through with the deal.
Exactly. A court order compelling performance. Her notes say it's most common for contracts involving unique goods like rare art or land. Land is always considered unique. The restaurant owner getting the specific plot of land is a good example.
But usually not for forcing someone to work, right?
Correct. Her notes likely state courts strongly disfavor ordering specific performance of personal service contracts, too much like involuntary servitude, and difficult for the court to supervise. Money damages are usually considered adequate.
What are other equitable remedies?
Injunctions, ordering someone not to do something like violating a reasonable non-compete. Rescission, canceling the contract and restoring parties to their pre-contract positions via restitution. Reformation, rewriting the contract to reflect the party's true agreement if the writing has a mistake, like a typo in the price, due to mutual mistake or sometimes fraud.
We also mentioned reliance and restitution interests as alternatives to expectation damages.
Yes. If expectation damages are too speculative, a party might recover their reliance interest, the costs they incurred in reliance on the contract, putting them back to the position they were in before the contract. Restitution interest, again, prevents unjust enrichment by recovering the value of the benefit conferred on the breaching party.
Can the person who breached the contract ever recover anything?
Sometimes, yes. Her notes might mention that a breaching party can occasionally sue in restitution to recover the value of the benefit they conferred on the non-breaching party, but this recovery would be reduced by the damages the non-breaching party suffered because of the breach.
Okay, one last area. Third-party rights. When people who weren't part of the original deal get involved.
Right. Two main ways this happens: third-party beneficiaries and assignment delegation.
Third-party beneficiaries.
Yeah.
That's when the contract is meant to benefit someone else.
Exactly. Party A contracts with Party B, but the performance is intended to benefit Party C.
Can Party C sue if Party B doesn't perform?
Only if C is an intended beneficiary. Her notes stress this. The intent of the original contracting parties, A and B, is key. If they intended C to benefit directly, C has rights. If C just happens to benefit coincidentally, an incidental beneficiary, they have no right to sue.
The business partner dealership driver example. The driver was intended to benefit.
Yes, that sounds like a classic intended beneficiary scenario from her notes. The driver could sue the promisor, business partner, but the promisor could raise any defenses they had against the promisee, dealership, like the Statute of Frauds, if applicable.
What's the difference between Denny and creditor beneficiaries?
It depends on the promisee's, A's intent. If A intended B's performance as a gift to C, C is a dumb beneficiary. If A intended B's performance to satisfy a debt, A owed to C, C is a creditor beneficiary. A key difference her notes might point out: a creditor beneficiary can usually sue the promisee, A, on the original debt if the promisor, B, doesn't pay. A done beneficiary generally cannot sue the promisee.
When do the beneficiary's rights become vested so A and B can't just change the deal?
Rights vest, according to her notes, when the beneficiary either 1. Materially relies on the promise, 2. Formally assents to it when asked, or 3. Files a lawsuit to enforce it. Before vesting, A and B can usually modify or rescind the contract without C's consent.
Okay, then assignment and delegation. Transferring rights and duties.
Assignment is transferring a contract right, like the right to receive payment, to a third party, the assignee. The original party with the right is the assigner. The party who owes the duty is the obligor.
Are assignments always final?
Assignments made for value, in exchange for something, are generally irrevocable. Gratuitous assignments, gifts, are usually revocable by the assignor unless the assignee has already relied detrimentally, or the assigner delivers some token representing the right, like a savings passbook. Her notes might add the nuance that even an irrevocable gratuitous assignment might sometimes be overtaken by a later assignment for value if certain formalities aren't met.
What rights does the assignee have?
The assignee basically steps into the assigner's shoes. They can sue the obligor directly, but the obligor can assert against the assignee any defenses they could have asserted against the original assignor. Her notes likely also cover priority rules. If the same right gets assigned twice, usually, the first assignee for value wins, but there are exceptions.
And delegation is transferring the duty to perform.
Right. Handing off the obligation. The original obligor is the delegator. The third party taking on the duty is the delegatee. The person owed performance is the obli.
Does delegating get the original party off the hook?
No. This is crucial from her notes. Unless there's a novation, the original delegator remains liable on the contract if the delegatee fails to perform. The delegator essentially becomes a surety.
Does the obligee have to accept performance from the delegatee?
Generally, yes, unless the duty is considered non-delegable. Her notes likely explain that personal service contracts involving unique skill or judgment are usually non-delegable because the obligee contracted specifically for the delegator's personal performance.
And novation ties in here, too.
Yes, novation is how the delegator does get off the hook. It's that three-party agreement where the obligee explicitly agrees to release the original delegator and accept performance solely from the delegatee. That discharges the delegator.
Whew. Okay, that was a lot.
Yeah.
But incredibly thorough. From forming the contract to remedies and third parties, we've really hit the highlights of contracts law, pulling heavily from Angela's fantastic notes.
It really ties it all together, doesn't it? And contracts is just so foundational for everything else you'll study.
Absolutely. And speaking of everything else, that actually concludes our deep dive series on contracts. It's been quite the journey.
It has.
Our next big topic is going to be evidence, which, flows really naturally from contracts. Once you know the rights and duties, you need to know how to actually prove things in court.
Exactly. How to get testimony admitted, handle documents, objections. It's the practical application of enforcing those rights we've been talking about.
So before we officially switch gears from contracts to evidence, we just have a few quick but important housekeeping items.
Right. First, just remember, Angela, whose notes formed the basis for this series, is a law student, like many of you listening. She's not a practicing attorney, hasn't passed a state bar yet, though her notes do mention she is barred in 2 Native American tribal courts, which is impressive.
Very impressive. And second, it's really crucial you understand. Nothing in this deep dive, not from Angela's notes, not from our discussion, constitutes legal advice. This is purely for educational purposes to help with your studies.
Absolutely. Using AI like us to process notes is a study aid. It's not a replacement for you doing the hard work of learning the law yourself.
And, sometimes we might make mistakes. AI isn't perfect. The source material might have had an error. Angela does try to catch and fix things in her notes, but ultimately you need to verify this information yourself. That's part of the study process.
Definitely double check against your casebooks and other resources. And finally, and maybe most importantly, if you are listening to this while driving, please prioritize your safety.
Yes, please. If thinking about mutual mistake or liquidated damages starts making your focus drift, just hit pause. You can always come back to it later.
Seriously, don't let contract law cause a breach of your duty of reasonable care behind the wheel.
Small chuckle. Okay. Be safe.
Now, if you want to learn more about Angela's comprehensive archive of law school notes that powered this whole contract series, you can email her. The address is podcast@studyforthebarinyourcar.com.
And one more thing. Angela also works as a freelance law clerk. So if you happen to be an attorney, or if you know one who needs some ad hoc help with legal writing, things like motions, complaints, briefs, answers, writs, you can reach her for that at hello@legalwriterandlawclerk.com.
All right, and now I believe it's time for the traditional cheesy lawyer joke to send us off from contracts.
Okay, I'm ready. Or maybe not. Why did the lawyer bring a ladder to court?
Uh-oh. Why did the lawyer bring a ladder to court?
Because she wanted to reach the higher court.
Oh, boy. Okay, that's one way to wrap up contracts.
Small chuckle. Well, this is Claude and Maud, your AI bots, signing off on Contracts Law.
It's been fun. We'll see you on the next deep dive into evidence.
Goodbye, and thank you for listening.